I ask the same question, Congressman? So, I read, it's the first few paragraphs, no? Sabi kasi dito, you heard me naman, no? You want me to read it again, no?
If I may be allowed to respond already to this
yes,
question. First of all, Your Honor, I think we must point out one of the plainest reasons why that statement in the Duterte ruling is obiter dictum. And that simply is because there was no trial yet to speak of when the Supreme Court rendered that decision. Paano po magiging issue yung nangyayari ngayon sa trial, samantalang nung dinesisyonan po yan ay wala pa pong trial? Therefore, any statements by the court about how the trial should be conducted are outside the issues of that case. And while they may be guidelines, they are not binding as judicial precedent to us and to the future generations.
Actually, I was referring to a different matter already, but just to that point, it's not how, it's what. It's paragraph 6. So the basis of the charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. For the President and Vice President, these acts must be sufficiently grave, amounting to the crimes described in Article 11, Section 3(1) of betrayal of public trust given by the majority of the electorate. For the other impeachable officers, the acts must be sufficiently grave that they undermine and outweigh the respect for their constitutional independence and autonomy. So this doesn't really tell us how to conduct the trial. This basically tells us is that if we don't follow that, we're endangered of having a trial that's void ab initio.
I would have to respectfully disagree, Your Honor.
Anyway, we've gone through that argument, and I won't argue with both of you. Going back to that, this is what I read. No? Second, considering the nature of the offices and the institutions that are subject to impeachment, its effects on independence of constitutional department and organs, and its nature as a constitutional process, all legal issues involving impeachment proceedings are subject to judicial review. I'll stop there. Kasi nabanggit po kanina, may I speak English Filipino? Nabanggit po kanina na that's for us to decide. And my interpretation, and I felt like that many times, diba, na zealous dapat ang impeachment court sa powers niya. Kasi not only because it's sui generis, wala tong apologize to Senator Judge Ruiz, my phone fell. So, wala nga tong, you cannot appeal the decision of my belief, no? You cannot appeal the decision of to acquit or to convict to the Supreme Court, diba? But the parameters, so let me use the words of the Supreme Court, no? Ang sabi niya, all legal issues involving impeachment proceeding are subject to judicial review. So, you disagree with this or you agree? In context ng sinabi mo kanina na it's within our power to make these decisions.
I believe what is the controlling decisions there, Your Honor, are the cases of Gutierrez and Francisco. Because in those cases, the issue of what is an impeachable offense was squarely brought before the court, and the court said very clearly that that is purely a political question that's not within the judicial power for us to decide, and I believe that that should be the controlling jurisprudence.
So let me be more specific. So for example, we issue some subpoenas and we do not issue some. Can one or both of you, meaning the prosecution and defense, go to the Supreme Court and question it?
Well, there is always the possibility that some side, perhaps the defense, may claim that there's a grave abuse of discretion, I believe, as they have done in their other petitions filed, and therefore make an attempt to stop the proceedings before this court. But as I have said last week, Your Honor, in our opinion, this court has the sole and exclusive power to decide what an impeachable offense is, and no one, not even the Supreme Court, can dictate on this court in making that decision.
Yes. Same answer.
No, Your Honor.
So,
I have a different.
So, okay, you can go back to that question. Then my follow-up question was, so let's say certain orders of the court, can the prosecution or defense go up to the Supreme Court and question its constitutionality?
Yes, Your Honor. It is our position that either of the parties can do that. Why? Because sa atin nga, sabi natin kanina, that the Constitution cannot be read in isolation. So while the Constitution gives the sole power to the Senate to try an impeachment case, to try and hear an impeachment case, we must read this in conjunction with, again, Article 3, Bill of Rights, and Article 8, specifically Section 1, which is the power of judicial review. So pag sa tingin po ng isang panig, merong grave abuse of discretion na naganap, we are of the position that in fact, this is a justiciable issue and can be brought before the Supreme Court, Your Honor.
So at least in that small point, I think we all agree that if we think there's grave abuse of discretion, there's a possibility that the Supreme Court will take it up. Not referring to the subpoena, I'm talking in general. So I'll skip a few pages of my questions precisely because I wanted to elicit your opinions or your stand regarding the fact that the impeachment court is supreme, but it's not true that we can do anything or we can just make decisions that are not based on statutes and on legal orders. In fact, when the Supreme Court issued the TRO regarding the foreign accounts or the dollar account in the Corona case, the impeachment court voted to respect the TRO. No? But of course, we did vote. So there could have been a constitutional crisis if we voted not to. And then, of course, we know because of history, nag-waiver na lang si Chief Justice Corona. No? So can I go now to the ultimate facts? No? I don't know if Senator Joel, but Senator Pia asked a little bit about this. Just a quick review, or maybe, so we're also governed by the rules of court when it comes to ultimate facts. This is what Section 1 says. In general, every pleading shall contain in a methodological and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party relies on his or her claim of defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her will be clearly and concisely stated. So does the two counsels agree that sa ultimate facts you have to include the evidence?
I would make a distinction, Your Honor, between what we call ultimate facts and evidentiary facts, which are the pieces of evidence that could be used to come to the conclusion or to decide whether those ultimate facts are present in the case or not.
Yeah, I think all of us lawyers agree with that. There's a difference between ultimate facts and evidentiary facts. But the rules of court says, including evidence. Kasi kung walang including evidence, then ang kailangan mo lang i-file ultimate facts. Pero pag sinabing kasama ang evidence, for me, it doesn't mean that every single testimony in every single document should be attached. But so let me go to my second question. So pwede bang sa articles of impeachment, ultimate facts lang, walang naka-attach na evidence?
Ang requirement po sa pleading ay doon na dapat nakasaad ang ultimate facts. But if you look at the articles of impeachment that are before this court, it also contains evidentiary factual allegations to support the ultimate facts that are contained therein.
Thank you for that answer. Actually, that was my next question. Did it contain? And you answered it. So with respect to the Saballa and Cabrera impeachment complaints, is it correct that there was no authentic records that were attached when they were filed? Factual lang tong tanong ko.
If Your Honor, please, first of all, I would have to raise an issue with respect to whether this honorable court is acting as an appellate or review court of what happened during the House proceedings. The power of to initiate an impeachment complaint is exclusively lodged with the House, while the power to try and decide that the impeachment case is exclusively lodged with this honorable court. And I don't believe that it is part of the function to go back to what may have happened during the proceedings before the House, since the articles have already been transmitted to this
But
honorable
Counsel, even your students, colleagues, recognize that you're a brilliant man, you're very well learned sa law, but minsan mabilis. Kasi actually, that's not where I was going. Binaliktad ko lang. So two of my colleagues started with, or in your discussions, ano yung fishing expedition, going down to ultimate facts and evidentiary. Ako, I wanted to distinguish when is it a fishing expedition and when it's not. So I just wanted to know as a fact. Or can we take judicial notice that there was no authentic records in the Saballa and Cabrera?
What's the point again, Senator Judge? There were no authentic.
It was just preliminary because I wanted to compare it with other impeachment complaints, and I wanted to ask the question, when is it a fishing expedition or hindi? So these are legitimate questions. So factually, yung Saballa and Cabrera ba, may authentic records attached. Ang information ko wala, but I don't want to.
I believe, Senator Judge Alan, that the Zaballa and Cabrera complaints were attached as an annex,
Yes.
if I'm not mistaken, to the respondent's answer. Would that be correct, Attorney Po?
And to be fair, it was
As well as the annexes.
Yes.
Yes, sir.
In fact, the presiding officer noticed that it lacked a page in one of the annexes to the, I think, Zaballa complaint.
So,
Which
anyway,
they pointed out. So that's a fact.
Yeah,
So it's in the record, Senator Judge
factual
Alan.
lang po. So, in the absence of authentic supporting record, what factual basis did the prosecution rely on to say that allegations were sufficient in form and substance?
If I recall correctly, Your Honor, please, there were some attachments to both complaints. And I'm not aware of any rule in the House of Representatives as far as impeachment cases are concerned that limit what may be discussed or investigated by the committee to only what is contained and attached to the impeachment
I'm not
complaint.
questioning if there's an attachment. I'm questioning whether there was. I'm asking question. I'm not even questioning it. I'm asking questions on if there were authentic records. So I'll move on. No? In the complaint against President Bongbong Marcos, the finding was the complaint failed to establish any factual nexus between the president and an impeachable offense. What are presented were policy and disagreements and generalized accusations, not ultimate facts. Yun ang finding ng Committee on Justice. Correct?
Yes, Your Honor, to the best of my
So
recollection.
that's my question. After answering that question, does the prosecution agree that the requirement of alleging ultimate facts applies equally to all impeachment complaints, regardless of if it's the president or the vice president, regardless if it's the ombudsman or the COA chairman?
Yes, Your Honor, and as I recall, when the members of the committee examined the complaint filed against the president, the conclusion of the committee was in fact that there were only conclusions of law contained in that complaint, not allegations of ultimate facts.
Yes. Yet in that complaint, there were documents attached, authentic records, and the House did not ask na masupina yung AMLA, BIR, and bank records of the president.
The requirement, if Your Honor, please, of ultimate facts is really based on what is alleged in the petition or complaint
But
itself.
what was the exact words of counsel? Ang katotohanan ay hindi
Confidential.
confidential. So why in the case of President Marcos is the katotohanan confidential, but in the case of Vice President Sara, it's not confidential?
Wala naman po ako maalalang ruling ng committee in the case of the president na meron silang sinabing confidential. What I recall is that the conclusion was that the complaint did not allege ultimate facts.
So there was a conclusion even before asking for all of this. But in this case, there's a conclusion that there's no nexus between the president and an impeachable offense. In this case, walang authentic documents pero humihingi ng supina kasi yung katotohanan hindi confidential. So which goes to my well, first let me honor who I should honor, because it seems that the Lisa Masa complaint, which was endorsed by ACT party list, was here kanina, and I think Antonio Tino, I think Sara Lago was here the last week, and I think Representative Ko was here. So in their case kasi, I can say walang selective justice because they wanted the same standards of president and vice president. So that's my next question. We want fairness for everyone and for the Filipino people, but would it be unfair to require 20 years of documents from AMLA, BIR, and bank accounts from Vice President Sara without requiring the same from President Bongbong, considering that all of these scandals is happening during his administration?
If the allegations of the complaint against the president did in fact contain ultimate facts, I would see no reason why the Committee on Justice should not have proceeded with it.
So I'll take that answer. May I ask the same question? Rule 8, ultimate facts including evidence. So the answer of the prosecution was that basta may evidentiary facts. But ang nakalagay kasi sa section 1 ng Rule 8, including evidence, what is the position of the defense on this?
The defense follows strictly the rules, Your Honors. While I agree with the distinguished opposing counsel na iba yung ultimate facts and evidentiary facts, no? I don't want to blur that line. Tama naman po yung sinabi ng ating opposing. But yun nga po yung punto namin, no? In the Saballa and Cabrera complaints, wala pong ultimate facts at wala din pong evidence or evidentiary na nakakalakip doon po sa mga complaints, and which is the very issue that we brought up to the Supreme Court, Your Honor.
So if you were representing now the president and the opposing counsel was also asking for 20 years of records of AMLA, bank accounts, and BIR, would you still have the same position?
Your Honors,
That unless it is relevant and definite. I read in your pleadings, diba, in your position paper na yun yung. So kasi I'll ask na rin my next question. Why is it definite in your view?
Opo. So on the first question, yes, Your Honor. Even if I were to be representing the president now, I would have the same view, no? Na hindi po pwedeng ganun ka 20 years ang span ng mga documents na hiningi, precisely because the jurisprudence provides that for a valid subpoena to issue, it must be particularly described, plus yung sinasabi po natin na relevance. Now, to the second question as to why it is not particularly described, Your Honors, unang-una, let's start with the bank accounts. No? Yung bank accounts na naka-enumerate sa kanilang request, it is our position na yun po yung natawag kanina na fruit of the poisonous tree. Because as you can see, lahat po ng pinanggalingan na accounts na yan ay yung AMLAC, but which we are contesting. No? Sa amin po, unlawful po yung naging disclosure sa Committee on Justice. But more importantly, pangalawa, aside from just the mere bank accounts, the documents they're asking, Your Honors, while they are specified, kung titingnan mo talaga ng mabuti kung anong hinihingi nila, they're asking for all bank records without any assertion as to why all of these are relevant to prove whatever allegation they have stated in the articles of impeachment.
I'll skip many questions here and go to that question. But to be fair, Congressman Joknos, you said that's an exclusive authority, right, power of the House. So if I want to question the difference, I'll do that in either the Senate or as a private citizen. So I won't go into that. But I ask that now in context of whether or not the certain parameters in the subpoena you're asking for is valid or not. So let me just go to this series of questions. This is really a discussion into what is substantial facts, what's ultimate facts, what's essential facts, what are, and as you said, Attorney Powa, we don't want to bore everyone with that, but it's important in terms of due process. So basically, the ultimate facts are that establish the charge, in this case, unexplained wealth. So let me put it this way in my question to Attorney and Congressman Prosecutor Joc. No. So like if I say that may kilala akong politiko, commissioner ng ganito, or congressman, senator, whatever, ang salin niya was 1 peso, or what's a reasonable amount. Salin niya was 1 million, 20 years later, it's 20 million, versus the commissioner of BIR, in 5 years, it gained 50 million. Compared to this congressman ganito. Then I said, eto lang income niya, unexplained wealth yan. In your view, is that sufficient na for the impeachment court and to issue the subpoenas? Or do you have to specify na, for example, you say that commissioner, sa salin niya, he only had 2 cars, but he actually has more than 4. Therefore, paying subpoena para sa LTO. O that commissioner, ang sabi niya, isa lang ang bahay niya. Pero subpoena sa LRA kasi 4 ang nakita namin. Diba? Kasi on the later examples, medyo mas malinaw yung ultimate facts. Pero yung pag sinabi mo lang, eto salin, eto tumaas, which was my point actually in my last few vlogs, that just because tumaas yung salin, that doesn't mean that there's ill-gotten wealth. But my question there was, does that give us now the authority to get the bank accounts, the AMLA and the BIR? Because whatever we do in the impeachment court is for impeachable officers. But nanonood din yung Sandigan Bayan, nanonood din yung RTC, MTC, nanonood din yung Supreme Court. So whatever rule we have here, that will influence then how we deal with barangay captains all the way to anyone who's not impeachable. No?
For unexplained wealth, Your Honor, I believe the ultimate facts must include the following. First, that the person involved amassed wealth. Second, that wealth is manifestly disproportionate to that person's lawful income. So kailangan po natin makita kung ano yung kanyang kayamanan at kailangan natin ikumpara doon sa lehitimo niyang kinita. And that can be only determined by looking at the records that we are requesting from this honorable court.
No, but if you're just looking at the salin at yung kinita niya, so I'll give you an example. I won't name the person para walang mag-react. But he was senator, I think, in 1987, an outstanding human being. And he was telling us, etong lupa na to, nabili ko ng 1980 o 1970 na 50,000. Oh, nabenta ko ng 1990. Kaya lang sa salin, ang nakalagay kasi doon yung acquired cost. So nilagay ko 50,000. So kung titignan mo kami, then he named some other great senators, etc. na kasabayan niya, congressman at dito. Titignan mo si senator nito, kami lahat. O ang salin namin baka 5 million. Pero yung 100,000 na lupa na binili namin noon, baka 5 million, 20 million, 30 million. So if one of those officials suddenly sold the property and then placed the money that came in, so let's say the 100,000 property was sold for 5 million, but then for example, pinang-blow out niya sa pamilya yung 500,000 before December 31 of that year, mag-increase yung kanyang salin by 4.5 million. So if you just compare his income na sweldo niya with that will not show you that he has ill-gotten wealth. So compared na pagka in-allege ko na ang sweldo niya 200,000 pero bakit may bahay siya sa ganito na wala sa salin niya. Diba? So I agree na sundan natin yung ebidensya. If the salin is much more than what you're making, that could spark your curiosity, your suspicion, and continue to investigate. But do you make the conclusion now and file the impeachment case that since malayo yung salin sa income, therefore ill-gotten yun, without giving that person a way to explain before you subpoena every single document about their lives?
That's precisely why, Your Honor, they call it unexplained wealth. Doon po natin malalaman yan sa mga dokumento.
No, I agree.
Kung
They call it
sorry, Your Honor.
I'm sorry, I'm the one. Please continue.
Kung halimbawa sa binigyan niyong example ay nag-appreciate yung value of the land, then I would not call that unexplained. I would call that explained wealth.
Yes, but you're introducing a new concept now, unexplained wealth versus ill-gotten wealth. I agree with you. Unexplained wealth is that if you look at the salin at hindi tumutugma, may unexplained wealth. That's why you ask them to explain it. And then pag hindi maganda yung explanation and may ebidensya ka, then you can go against that person for ill-gotten wealth. Diba? But like in certain parts here, I saw some that I would consider even without asking you evidence. But for example, yung mga kumpanya, sabi dito lugi yung kumpanya. So kung lugi yung kumpanya, hindi makaka-contribute yun sa kanyang ill-gotten wealth kung meron man. So why are we getting all the documents about those companies? Doon pumapasok yung criticism ng iba, is this a fishing expedition? Kasi if I had 5 companies and they were all making money and supposedly I only own 1% of that company but I'm getting half of that income, I would agree with you, isupina lahat yan. Tingnan natin yung flow niyan, baka yun yung pumasok sa akin. Pero lugi nga yung mga kumpanya. As an example, so that's my point. Is it enough in the view of the prosecution panel just to allege, malaki yung salin mo, bigger than your monthly sweldo? Both of us agree, it's unexplained. But is it ill-gotten, or do you need more allegations to show that it was ill-gotten?
But, Your Honor, please, the decision whether wealth is unexplained or, as you said, ill-gotten is really a decision that this honorable court will make based on the evidence. Ang gusto lang po namin ay may latag ang ebidensya sa inyong harap para kayong na mismo magsabi. At para malaman po yan, we have to look at the statements of assets, liabilities, and net worth. We have to look at the lawful income reported in the ITRs. We have to look at the bank records in terms of kung ano yung pumasok at lumabas sa kanilang mga accounts. As far as, I'm sorry, Your Honor. As far as the businesses are concerned, that has to do with the third subcharge under unexplained wealth. Yung pong continuing to participate in business interests despite the clear and express prohibition provided in the Constitution. We want to know whether those businesses, yung ba ay mga operational ba ito ba ay talagang sasabihin natin na nandun yung sinasabi nga inaamin ni Vice President sa kanyang salin na business interest na niya yun.
Yeah, I'm skipping because this is mostly questions on fishing expedition. I'll go to the defense after this, but can you tell us the difference between evidence and proof? In your layman term or legal terms? Or if you want to look it up, but in how do we explain to people the difference between evidence and proof?
Napakabigat po ng inyong tanong.
In our words lang,
I will try
para
my best,
maintindihan.
Your Honor, to answer it. In a court proceeding, whether we're speaking of an impeachment court or a regular court, the judges look at the evidence. They may never be able to know the entire truth kasi ang pangyayari ay nangyari dati pa po. Essentially, a trial is really a reconstruction of something that happened before. So it may happen in some cases that there is enough evidence to make conclusions as far as the judgment is concerned, even if the members of the court did not get to see the entire truth.
Yes.
Ang gusto po namin maiwasan na dito sa impeachment court ay meron po tayong hindi mailatag na ebidensya sa mga maestrado po na nandito para talagang maging buo yung larawan nila bago po kayo magpapasya.
I don't think there's any question that all of us here want na mailatag yung ebidensya. The question is, do you have the evidence or are you fishing for the evidence? And that's a question not only for you, but for every single impeachment process, not only the umabot dito, because myself, Senator Subiri, Senator Chis Escudero, then later on Senator Villanueva, has been in the House many times during impeachment of presidents and chief justices. No? But the reason I ask between evidence and proof is because if you have the evidence, you want the opportunity, diba, to bring it here, show the relevancy, connect it to the crime, we admit it, so that if it's true, then we can convict. The opposite sides na will either question, hindi admissible yan, or admissible, pero walang relationship yan, etc. No? So what I'm saying is that if you're going to prove your case with no evidence, except that if you get all of that, then magiging arbitrary yung House of Representatives, sinong gusto nilang i-impeach, because almost any public official who's been there for a long time, you will see discrepancies in their SALN because unang-una iba yung acquisition cost at iba yung current value at iba din yung deadline ng December 31, no? Which after this I'll ask the defense to answer, then I'll go into the AMLA, which is different from bank accounts, no? So if you're coming to the court with evidence already, but kinukuha mo yung subpoena na yan, di ba, to further prove your point, I don't think there'll be a question there. As Attorney Poe said kanina na, kung yung BIR box na yan, alam natin yung laman, and dapat gamitin dito, they acknowledge nyo na. Pero kung hindi alam yung laman, are we fishing there if there's a tax evasion or wala? I don't know the answer. I'm asking you the question. You can answer it in any way you're comfortable in answering.
If I may briefly narrate the procedure that the House might had to undergo for the articles to reach this honorable court. When the complaints were filed before the House of Representatives, the Committee on Justice was tasked not with conducting a trial, not with ferreting out all the evidence, but simply determining whether there was probable cause to proceed with the case. So hindi po namin hinanap yung kabuuan ng ebidensya dahil hindi po namin tungkulin yon. When we made a determination that there was sufficient probable cause to proceed with that case, then that is what we submitted in terms of the articles of impeachment that reached this honorable court. Ngayon, syempre po, just like a preliminary investigation conducted by a prosecutor, ang hawak lang po niyang ebidensya, ang titingnan lang po niya ay kung merong probable cause. Not all the evidence yet is before that prosecutor because wala pa pong trial. The presentation of evidence, even the subpoena or compulsion to present evidence will only happen when the trial takes place. And yung tinutukoy po ninyong fishing expedition, yun ay maaaring sabihin natin nangyari kung only if the party requesting the evidence or documents ay nagbabaka sakali lang, baka may makuha tayo dito. In our case, I have to disagree that there was any sort of fishing expedition because based on what the Committee on Justice and later the plenary of the House found was sufficient, there was enough cause to proceed with the
I'll
case.
go to probable cause, but yung sinabi mo baka sakaling may makukuha dito. You said hindi ganun. So ano makukuha natin if we grant all the subpoenas you're requesting?
The evidentiary facts, Your Honor, that were not yet, hindi pa nakita ng House nung ang ginagawa lang po namin ay determinahin ang probable cause.
So nagbabakasakali din?
Hindi po.
No, kasi you said,
Because there is basis for requesting for
so
the
what will
bank
you see?
records.
You still don't know what you'll see.
We are basing the request for the bank records on the evidence and information provided by the Anti-Money Laundering Council, which appears to show that there were billions of pesos that went through the accounts of the Vice President during
Let's
that
go to
period
that
of
with the
time.
permission of the defense, then I think you're listing down naman. So the Anti-Money Laundering Council, no, does not deal with income, they deal with flow, right? So pag sinabing billion, that doesn't mean that a certain official has billions in their account. So meaning if I have ₱1 million deposit on January 1, and then on January 5, I take it out and put it in time deposit for 1 month, and 1 month later it comes out with a 2% time deposit, hindi na 1 million yon. 1 million in, 1 million out, 2 million, 1 million in the time deposit, 3 million. Paglabas na may 2%, 1 million 2 pesos, 1 million 2,000 pesos, 4 million na yon. So hindi evidential yun, speculation sa ikot ng pera. Meaning, all I have to do is find someone with a bank account and give them a long enough period, and I will say that they have hundreds of millions or billions.
Precisely, Your Honor, that is why we want the bank records to be produced. Because, as you mentioned, the only reports submitted by the Anti-Money Laundering Council pertain to covered and suspicious transaction reports. They do not show us the exact balances that were contained
And
in those bank accounts. And it is only the bank records that will provide that information.
Agree. And it's suspicion. When you say suspicion, that doesn't mean necessarily suspicion that it's attached to a AMLA crime. But it could be suspicious meaning 6 months walang gumagalaw, biglang everyday ngayon gumalaw. Diba? Yun yung definition ng part ng definition ng AMLA. But if you cannot connect AMLA and the bank accounts, that's precisely what the defense and other people are saying. Aren't you nga fishing between the three? Fishing means hindi mo pa hawak. So you're trying to get a fish, in this case a very big fish. Diba? So, pag sinabing hindi fishing expedition, meron ka ng ebidensya, but you want to prove that in court, and you need that to prove it, but you know what to prove already.
If we bring Your Honor's logic to its conclusion, that would mean that the Committee on Justice would have to conduct a full-blown trial, get all the evidence at that level, so that we do not have to fish anymore when we get to this court. When that is not the contemplation of the procedure for impeachment under the
I
Constitution.
won't argue what the,
With
what the House...
the permission of the gentleman of the floor, Senator Cayetano,
Last 2 questions.
thank you very much.
So, Senator Escudero, myself, we were in the Estrada and Arroyo impeachment. It's harder to impeach a president than a vice president. Di ba? But whether it was accounts, anong laman, property, kotse, we did our homework. So it's not my place to tell you did or not. Kaya nga tinatanong ko, may ebidensya ba o wala? Or is it a fishing expedition or not? But as I said a while ago, I won't argue. So I have one last question after that, but I'll go first to the defense. In the context of what I asked, no? Between those two examples, ito salian mo, ito income mo, malaki salian mo. Oh, we can agree it's unexplained. Kasi nga, you need to explain it further. But is it automatically ill-gotten wealth?
No, Your Honor.
So if it's not automatically ill-gotten wealth, in your view, I mean, I read this from your, maybe you can just restate, why is it a fishing expedition?
Opo. Your Honor, because precisely, yun pong sinasabi nila na unexplained wealth. They were basing it for 20 years, for one. No? Pangalawa, they couldn't pinpoint exactly bakit mo nasabing may unexplained. Alin dito sa properties yun unexplained. No? Third, and if I may elaborate from our memo, if you look at the articles of impeachment, it presupposes that the Vice President earned 30 million over a span of 20 years. Yes, they did not think about the Vice President not being in public office from 2013 to 2016. They didn't think about the income that could have been generated by being married to a lawyer who had his own law office. So to us, it was basically a conjecture, speculation, conclusion of law and fact to say, biglang, uy, may unexplained wealth po dito. No? That's basically our point. And then secondly, the decision earlier, it was mentioned by distinguished opposing counsel, decision rests upon this court to determine kung meron ng unexplained wealth. I disagree with that. The ultimate decision rests upon this court, that is true. But the initial decision rests with the person accusing, di ba? Pero nung accuse yung tao sa Sabalian Cabrera complaints, wala man lang nakasulat po doon. Kanina na-mention po yung should the Committee on Justice now conduct a full-blown trial? No, it shouldn't. It should just evaluate the complaint. Parang nga pong piskal, parang preliminary investigation. Pag tayo po pumunta sa piskal at ang dala lang natin doon ay puro paratang, wala man lang supporting document, what will the fiscal do? Dismiss the case outright. Yan naman po ang totoo. No? So that was our point to begin with, and that is why we're saying fishing expedition ito. Kasi hindi mo man lang mapinpoint kung anong transaction yung sinasabi mong nag-amass ang Vice President natin. Anong taon na nag-amass yung Vice President natin ng ill-gotten wealth or unexplained wealth. At dahil doon ngayon, we're asking for records spanning 20 years, both BIR records, bank records, AMLAC records, which they already have actually from the Committee on Justice. Pero hindi natin mapinpoint alin ba talaga dito. We cannot specify kung ano yung act, ano yung omission na ginawa niya na nakapag-amass siya ng unexplained wealth.
Talking about both parties talking about the fiscal or prosecutor, actually binago na rin ngayon. Probable cause with reasonable certainty mako-convict. So meaning you go to the fiscal's office that you point out ano yung crime, sino yung gumawa ng crime, and yung preliminary evidence mo might not be enough to convict at the time, but enough to say na hindi lang to marites. So if I go to the fiscal's office or ombudsman saying this senator has 150 million in SALN, 10 years ago it was 50 million, therefore it's ill-gotten wealth, and then wala pa akong ibang dala except yung magkano sweldo dito, I doubt the fiscal will file the case. But if I tell the fiscal that he has 2 cars in his SALN, but eto, I see him using 4, then give him the opportunity. But I can subpoena the LTO. Na kanino ba yung plate number na yan? Baka namang nasa kapatid talaga niya, no? But the last set of questions, I'll just ask it once, no? So I think everyone understands naman the subpoena regarding the Vice President. The issue was really the dates and how specific or hindi. Actually 2 questions. The corporations, do you not have to pierce the corporate veil, considering there's no allegations in the articles that these companies were used to amass ill-gotten wealth? In fact, I haven't read everything, but so far sa binasa ko, is hindi kumikita tong mga kumpanya na to. Because there's a Supreme Court decision that if it's a joint account, may rights din yung isa. And I don't even know if we informed all of those companies that we might subpoena their records. So did we give them that opportunity? Isama ko na yung last question, Mr. Presiding Officer, and I won't follow it up, no? But yeah, the question was, because a law student asked me, Sir, bakit dinala yung box dito sa Senate? Ba't na lang hindi nila binuksan sa House? So sinagot ko sa kanila, ano ba turo ng professor nyo? Sir, hindi naman nakalagay impeachment trial in cases of impeachment. So the House was actually empowered to open the box there. So I just wanna know the position of both parties kasi nahiwagaan ako sa box na yon. Si Neil dinala dito, ibabalik sa inyo rin, magsusupina tayo. But dun sa graduate na yung nagtanong sa akin nun, they discussed it down in class, and their professor and their class, ang consensus is that the House could have opened it because the wording in the is it the BIR case or the bank accounts? No, bank accounts ata, yung in cases of impeachment yung nakalagay dun sa
Bank accounts, secrecy of bank deposits.
Yes. So ang question niya, let me rephrase, is that did you do that there? So if you did that there, hawak nyo na ngayon. Hindi na namin problema sana. No? So those 2 questions lang regarding do you think na-comply yung requirements dun sa companies, and should we give notice to the companies? And secondly about bank account, could you have opened it already in the House? In BIR din ba?
Counsel for the panel prosecutors may respond, thereafter counsel for respondents.
Thank you, Your Honor.
And we would like to thank
Counsel, thank you
Senator
very
Judge
much.
Allen for his interjections.
If Your Honor, please, the doctrine of piercing the corporate veil applies when we are determining liability of the company or corporation involved. In this particular case, that doctrine has no application at all. We are asking for those records to be produced so that we can determine the extent of participation of the Vice President, as she herself had admitted those business interests in her silence. Kaya po namin hinihingi po yun. Kasi tingin po namin ay wala pong aplikasyon ang piercing the corporate veil. Second, as far as opening the box is concerned, while it is true that under Republic Act 1405, there's no qualification that impeachment trial lang po ang pwede. As I understand it, it was the better judgment of the committee out of sheer discretion and prudence not to, because at that time we were already being bombarded with petitions left and right seeking to restrain our proceedings, and we felt that it would be more prudent to bring the matter to this honorable court. Thank you.
Your Honor,
Counsel for the respondent.
on the first point, Your Honors, on piercing of the corporate veil, Para sa amin, pwede lang naman under jurisprudence mag-pierce ang corporate veil. Ibig sabihin, kasi separate and distinct personality ng mga korporasyon, you can pierce that veil if there's an allegation of fraud. And in this case, wala naman pong allegation ng fraud. Pangalawa, kung totoo po na talagang hinahanap lang po ng pinakagalang-galang na prosecution ay tungkol dun sa divestment issue, then they will not need the tax records, the bank records, or even the AMLAC records of these companies because all they need will be the GIS. The General Information Sheet would show you exactly the extent of the interest of the stockholders, hindi po ba? Pangalawa, pagdating naman po dun sa what's our position, pagdating sa bank secrecy and the exception on cases of impeachment. Sa aming pananaw, at the committee level, meaning Committee on Justice, ay hindi pa po applicable yung exception na ito. And we are holding on to the ruling of Marquez versus Ombudsman or Desierto, I believe, no? Wherein it was said na pagdating sa preliminary investigation, hindi pa po applicable yung mga exceptions under the Bank Secrecy Act, and there has to be a pending case before such bank documents are in fact subpoenaed. That is our position, Your Honors.
Thank you, counsels, for the parties. Chair will now make a ruling, but prior to that ruling, Chair would like to inquire very, very briefly from the counsels. First, for the counsel for respondent, may the court know when the respondent was married to her spouse and what is the property regime governing their marriage?
Your Honor, I believe they were married, but let me just check the facts just to be sure, but I think it was 2007. 2007, Your Honor, can I get back to you on the specific date for that?
The date would not be necessary because 2007 would mean they would be covered under the family code. So may the
Yes, Your
chair
Honor.
ask, what is the property regime governing their marriage?
As far as I know, there are no property regime arrangements or prenup. That's why, Your Honor, I would assume it would be the default property regime, which should be
The absolute
absolute
community of property. Thank you, counsel. Chair will now make its ruling. The impeachment court will now resolve the prosecution's renewed request for the issuance of subpoena ducis tecum dated July 6, 2026. You may seat, counsels. Directed to the concerned banking institutions and anti-money laundering council. The court begins with the standards governing the issuance of subpoena ducis tecum. These are set forth in Section 3, Rule 21 of the Rules of Court, which provides, among others, that in the case of a subpoena ducis tecum, it shall contain a reasonable description of the books, documents, or things demanded, which must appear to the court as prima facie relevant. Settled jurisprudence has affirmed and clarified these requirements. In the 2021 case of Republic versus Sandigan Bayan, dated 2/15/21, where the Supreme Court stated, quote, a subpoena ducis tecum may be issued if the tests of relevancy and definiteness are satisfied. The court must ensure that, number one, the books, documents, or other things requested must appear prima facie relevant to the issue, subject of the controversy, the test of relevancy, and number two, such books must be reasonably described by the parties to be readily identified, the test of definiteness. In the case of BSB Group Inc. versus Go, GR number 168644, the court stated that evidence is relevant when it bears such a direct relation to the fact in issue as to induce a belief in its existence or non-existence, and when it relates to a collateral fact from which the existence or non-existence of the principal fact may logically be inferred. These requirements are intended to ensure that the subpoena is not used, as mentioned earlier and discussed earlier, as a tool for a fishing expedition as held in Apostol versus Lubingan Rafael, GR number 260640, dated October 1, 2025. We are also aware of the ruling of the Supreme Court in HC Libenau versus Philippine National Oil Company, GR number L13463, quote, a general inquisitorial examination of all the books, papers, and documents of an adversary conducted with a view to ascertain whether something of value may or may not show up will not be enforced. However, after a careful examination of the records requested, the court finds that the requested documents meet the requirements set forth above. They are reasonably described, readily identifiable, prima facie relevant, and material to the allegations under Article 2. This is not the first time that bank records have been examined by an impeachment trial. During the impeachment trial of former Chief Justice Corona, the Senate sitting as an impeachment court granted the prosecution's request for the production of bank records. In granting that request, the court cited Section 2 of Republic Act number 1405, which expressly recognizes cases of impeachment as an exception to the confidentiality of bank deposits and the rights to privacy of depositors. As to the requested period from 2007 to 2021, the defense's objection is overruled. The respondent's invocation of what they refer to as offenses in term, quote-unquote, in their memorandum, doctrine in Duterte versus HOR, does not avail. First, the documents requested under the subpoena ducis tecum will not be used to allege additional independent impeachable offenses. The court will not allow this in adherence to the doctrine laid down in Duterte v. HOR, as this will violate the respondent's right to be informed of the nature and cause of the accusations against her and her rights to due process at every stage of the proceedings. Rather, the court will only allow these records to be used to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. Establishing such a factual baseline is recognized in settled jurisprudence involving allegations that a public officer's wealth is manifestly disproportionate to the lawful income and financial capacity of the officer and the officer's spouse. As held by the Supreme Court in Concerned Taxpayer versus Doblada Jr., dated 8 June 2005, quote, in determining whether the properties acquired were manifestly out of proportion to the lawful income of the spouses, necessarily requires comparing their value with the spouse's salaries, benefits, other lawful income, and revenues from legitimately acquired properties or businesses. Further, in the case of Ombudsman v. Bernardo, GR number 181598, quote, respondent's beginning net worth must be considered for purposes of determining whether his disposable income was more than sufficient to justify his property acquisitions and foreign travels for the covered period, and whether he possesses the financial capability to acquire or purchase properties as reported in his SAL-N. Quote, such net worth of the respondent as declared in the statement filed by him or her from the first day of his employment with the government shall be considered as his true net worth as of such date for purposes of determining his capacity for future property acquisitions during his tenure as a public officer. Any unexplained increase in his net worth thereafter may fall within the ambit of the presumption provided for in Republic Act number 1379. The production, therefore, of the records from 2007 to 2021 is authorized strictly for that limited purpose only. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term in relation only to Article 2 of the Articles of Impeachment. Now, with regard to the bank records held separately by attorney Manasseh Carpio and jointly by him and the respondent, the defense's objection is likewise overruled. The respondent's reliance on Republic versus Eugenio is unavailing. That case involved only an ordinary civil inquiry into spousal assets that were not statutorily aggregated. On the other hand, Section 8 of Republic Act number 6713 requires public officials to disclose their assets, including that of their spouses. Their financial interests are therefore statutorily intertwined for purposes of disclosure. Respondent likewise insists on the separate legal personality and distinct right to privacy of attorney Carpio, but this is likewise untenable. Article 75 of the Family Code explicitly provides, which is why the presiding officer earlier asked the property regime governing them. In the absence of a marriage settlement or when the regime agreed upon is void, the system of absolute community of properties established in this code shall govern. Under this regime, Article 91 dictates that community property shall consist of all the property owned by the spouses at the time of the celebration of marriage or acquired thereafter. Furthermore, the family code of personal information, requiring strict scrutiny, quote unquote, citing Zoleta versus Ombudsman. The court, however, in Zoleta did not really use the phrase strict scrutiny, but said strict adherence to the Data Privacy Act. Accordingly, Section 16B of the Data Privacy Act expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of the DPA, Data Privacy Act Implementing Rules, expressly permits the processing of sensitive information, personal information, when provided to government or public authority pursuant to a constitutional or statutory mandate, and when necessary for the protection of lawful rights, interests in court proceedings. Now, as to the 21 listed corporate entities and partnership, the requests are granted with respect only to 19 corporate entities and partnership. The respondent's connection to these entities is prima facie shown by the general information sheets in the articles of partnership, which have been pre-marked in evidence and by your admitted sal ends from 2022 to 2025. The request, therefore, is not considered as a fishing expedition, and subpoenas may issue for their peso-denominated accounts strictly only in relation to Article 2. However, the request directed to banking institutions concerning JTC Group of Companies and Pikimong Philippines Corporation are denied. Their general information sheets do not identify the respondent or her spouse as shareholders, and the prosecution at this time failed to show either direct business interest or a clear and convincing basis to disregard their separate juridical personalities. As held in Pantranco Employees Association v. NLRC, GR 170689, and Lanuza versus BF Corporation, GR number 174938, the corporate veil may not be pierced on mere suspicion or speculation. Misuse of the corporation as an alter ego, conduit, or instrument of fraud must be clearly established. Absent such proof, these entities cannot be subjected to the compulsory process intended for another. As to the request for subpoena against the partnership of RP lawyers, the same is granted with the following reservation: in adherence to Subido versus Pagante Certeza Mendoza and Binay Law Offices versus Court of Appeals, GR number 216914. The chair notes the practical reality that an examination of a law firm's bank accounts may incidentally disclose sensitive information relating to its clients and legal engagements. The court acknowledges that the partnership and/or the clients of Carpi lawyers may seek appropriate remedies and to challenge compliance with applicable legal requirements, particularly in light of the potential legal implications, including concerns relating to attorney-client privilege, which may also be raised during the trial proper. Furthermore, the court must draw a legal firm line regarding foreign currency deposits. Foreign currency deposits are governed by Republic Act number 6426, particularly Section 8, which recognizes only one exception to confidentiality: the written permission of the depositor. This is also guided by the President arising from the 2012 Corona impeachment trial. On February 19, 2012, the Supreme Court issued a temporary restraining order in PS Bank versus Senate Impeachment Court, GR number 200-238, enjoining the Senate from opening the Chief Justice's Corona dollar accounts in the absence of a written waiver of the depositor. Accordingly, insofar as the request covers foreign currency deposits of the respondent, her spouse, separately or jointly, as well as the corporation and partnership, it is denied. Such accounts shall be excluded unless and until written consent of the respective depositors is produced. The court now turns to the records held by the MLC or Anti-Money Laundering Council. As to the request directed to the Anti-Money Laundering Council, the same are granted with respect to the respondent, her spouse, and the 19 entities and one partnership, for which a prima facie connection has been shown through the pre-marked general information sheets, articles of partnership, and the respondent's admitted salience. However, the requests as to JTC Group of Companies and Pikimong Philippines Corporation are denied for failure at this stage to establish a prima facie link, the respondent or her spouse and said entities, or any sufficient basis to disregard their separate juridical personalities as previously stated. The defense vigorously argues that the MLC is absolutely shielded from this court's compulsory process by the confidentiality provisions of Section 80 of the Anti-Money Laundering Act, as amended, and warrants that compliance would expose MLC officers to criminal sanctions for breach of confidentiality. The court, however, finds this argument unavailing. Section 8A regulates unauthorized and arbitrary disclosures by AMLAC personnel. It does not and constitutionally cannot nullify the lawful subpoena powers of the Senate sitting as an impeachment court, where compliance with the lawful constitutional subpoena is a justifying circumstances that, if at all, would extinguish any penal liability under Article 11, Paragraph 6 of the Revised Penal Code for any person acting in obedience to an order issued by superior or some lawful purpose. In the landmark case of Republic versus Sandigan Bayan, GR 2322724, the Supreme Court explicitly rejected the MLC's attempt to quash a subpoena to Sistecum, ruling verbatim, quote, "The Anti-Money Laundering Council is not merely a repository of reports and information uncovered and suspicious transactions. It was created precisely to investigate and institute charges against those suspected to commit money laundering activities. The criminal prosecution of such activities would be unduly hampered if we were to prohibit it from disclosing such information. For the Anti-Money Laundering Council to refuse disclosing the information required of it would be to go against its very function under the law." Further, as held by the Supreme Court in Sabio versus Gordon, GR number 174340, by parity explained that statutory provisions on confidentiality and exemptions from inquiry cannot be invoked to deny access to information by Congress in aid of legislation. It is therefore the position of this court that if the Sandigan Bayan pursuant to its subpoena powers cannot be denied AMLC records as well as the legislature in aid of legislation, it most certainly cannot be denied to the Senate sitting as an impeachment court. The defense also vehemently objects to the production of AMLC documents by pointing out to the agency's own printed footnotes, which restrict the reports for intelligence purposes only, quote unquote, and explicitly state they are not to be used as evidence in any formal proceedings. The court, however, overrules this objection. The admissibility and evidentiary weight of documents in an impeachment trial are determined by the Constitution, the rules of court, and the judgment of the impeachment court, not by unilateral disclaimers printed by an executive agency on its letterhead. An administrative footnote or internal intelligence sharing protocol cannot rise to the level of a constitutional or statutory exclusionary rule. While the MLC's internal protocols are validly designed to prevent premature leaks during ongoing investigations, they cannot legally operate to tie the hands of the impeachment court once the documents are lawfully subpoenaed. Because the requested suspicious transaction reports and covered transaction reports satisfy the threshold of prima facie relevance in tracing the alleged accumulation of unexplained wealth under Article 2, they shall be produced. The defense further invokes the 5-year record retention period under the AMLA regulations. The 5-year period is a minimum mandatory retention requirement imposed on covered institutions. It is not an absolute prohibition against keeping or producing older records. Accordingly, let the AMLC invoke this limitation in its return, which this court shall take into account and inform the parties thereon accordingly, should they be unable to comply with the subpoena. As for the partnership of Carpi lawyers, Section 1 of Republic Act number 10365, amending Section 3A7 of Republic Act number 9160, treats as covered persons those including lawyers who manage client money or assets, manage bank savings and securities accounts, organize contributions for companies, or create, operate, or manage judicial persons or arrangements. Section 2C of MLC Regulatory Issuance B number 1 series of 2018 adopted on May 10, 2018 and filed on June 13, 2018 expressly reiterates this activity-based rule. The court recognizes the statutory exception for lawyers acting as independent legal professionals, where the information concerns their clients or disclosure would compromise client confidences or the attorney-client relationship. Absent any showing, however, that the particular record sought contains such information or would compromise a protected confidence, the exception cannot be invoked merely because the entity concerned is a law partnership. It protects client confidences. It does not confer a blanket immunity upon every financial record bearing the law firm's name. The request for the issuance of subpoenas for the identified financial records therefore pertaining to Carpi lawyers is granted, subject to the remedies in law and or their legal right to assert a specific claim of privilege over a particular document at the proper time. No generalized blanket invocation of attorney-client privilege shall excuse compliance at this time. Therefore, to summarize, the court rules as follows. The request for subpoenas directed to the concerned banking institutions covering the accounts of respondent, Attorney Manasseh Carpio, separately or jointly, the partnership of Carpi lawyers, and the 19 listed corporate entities is granted. The banks are ordered to submit to the clerk of court the documents on July 30, 2026 at 9 a.m. with attendance of parties and counsels. The request insofar as it seeks the records pertaining to JTC Group of Companies and Pikimong Philippines Corporation is denied for failing to establish prima facie relevance. The subpoenas granted shall apply only to peso-denominated accounts relevant to Article 2. Foreign currency deposits are excluded absent the written consent of the respective depositors. The subpoena directed to the Anti-Money Laundering Council covering respondent Attorney Manasseh Carpio separately and jointly with respondent, the partnership of Carpion lawyers, and the 19 listed corporations and entities is granted. The request insofar as it seeks records pertaining to JTC Group of Companies and Pikimong Philippines Corporation is denied for failing to establish prima facie relevance. Finally, the court is cognizant of the Supreme Court ruling in Almonte v. Vasquez GR 95367, where it stated that a government privilege against disclosure is recognized with respect to state secrets, and it is not amiss to state that even matters of national security have been inquired into in appropriate in-camera proceedings by the court. Therefore, the court ex abundante ad cautela or out of an abundance of caution hereby directs, in order to prevent the unwarranted exposure of sensitive AMLC methodologies and information, to submit the records strictly in camera to the presiding officer through the clerk of court first, on July 30, 2026 at 9 a.m., who shall review these documents privately before turning them over to the parties as may be warranted. The parties are directed to be represented by counsel on the aforementioned time and date for the proper inspection, comparison, photocopying, and or marking of these documents as the case may be. So ordered. Moving now on. The impeachment court will now resolve the prosecution's request for the issuance of subpoena dated July 6, 2026, directed to the Commission on Internal Revenue. At the outset, the presiding officer reiterates and adopts by reference the court's citation of applicable rules regarding the issuance of subpoena to Sistecom, which forms an integral part of this order. The foregoing standards are deemed reproduced and shall govern the court's disposition of the present subpoena requests. After examining the records sought, the court finds that the requested documents meet the requirements set forth. They are reasonably described, readily identifiable, and prima facie relevant and material to the allegations under Article 2. However, the court, similarly, requests, insofar as it seeks the records of JTC Group of Companies, Philippines Inc. and Pikimong Philippines Corporation. The prosecution failed to establish a prima facie nexus between these entities to either the respondent or to her spouse. The records sought therefore do not at this time satisfy the requirement of prima facie relevance under Rule 21 of the Rules of Civil Procedure. The court also resolves the respondent's objection to the requested period from 2007 to 2021. They anchor their opposition on the Supreme Court's pronouncement in Duterte v. HOR that the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. The argument, as stated earlier, fails because first, the documents requested under the subpoena to Sistecom will not be used to allege additional impeachable offenses. This court will not allow it. For the same reasons discussed in the court's earlier order, consistent with the same jurisprudence which are hereby adopted by reference, the court likewise holds that the requested records are sought to establish respondents' financial baseline and capacity only, not to inquire into or prosecute alleged impeachable acts occurring outside the present articles of impeachment. Accordingly, these records are required to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. We are also not without precedent. During the Corona impeachment trial, the Salians, prior to his appointment as Chief Justice in 2010, were presented on the January 18, 2012 hearing of the court. Likewise, evidence and testimony concerning properties and transactions before his appointment as Associate Justice were presented before the court on March 13, 2012. Therefore, the production of records from 2007 to 2021 is therefore allowed and authorized strictly for purposes of establishing a comparative baseline only. They shall not be used as proof of another independent impeachable offense. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term. The defense's invocation of the Race of the Privacy Act is likewise unavailing. As previously stated, Section 16B of that law expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of its implementing rules expressly permits the processing of sensitive personal information provided to government public authority pursuant to a constitutional or statutory mandate and when necessary for the protection of lawful rights and interests and court proceedings. The court is likewise unconvinced by respondents' argument that the issuance of the subpoena will usurp the authority of the BIR under Section 5 of the NIRC. This court is not determining the tax deficiencies or civil liabilities which remain within the province of the BIR. It is exercising its constitutional mandate to determine public accountability under the articles of impeachment. Neither does the dependency of a BIR audit suspend or limit the Senate's exclusive jurisdiction to try impeachment cases. The respondent invokes Section 270 of the National Internal Revenue Code to prevent the production of the requested records. The objection is overruled in part. The Supreme Court expressly ruled in Dipad v. Spouses Olivan GR 168771 that Section 270 of the NIRC obviously does not address the confidentiality of ITRs. It merely penalizes the unauthorized disclosure of taxpayer information, except as otherwise provided for by law. It does not bar the production of the documents. However, the respondent correctly invokes Section 71 and other provisions of the NIRC which recognizes only 3 instances in which a taxpayer's records may be open for inspection. Number 1, upon order of the President or authorization of the President. Number 2, upon the request of a foreign tax authority with approval of the President. Or number 3, upon the taxpayer's waiver. Nevertheless, the existence of these statutory limitations does not at this stage preclude the issuance of the requested subpoena. The issuance of subpoena is merely a preliminary procedural step and does not by itself authorize the disclosure, inspection, or admission of the requested tax records into evidence. In fact, this issuance is the order that shall set, if at all, things in motion. Upon service, the BIR Commissioner may refuse compliance, very much like what they do in the House, or comply by invoking any of the exceptions under the NIRC as previously mentioned. without a satisfactory showing of faithful compliance with any of the enumerated exceptions, this court shall not receive any subpoenaed records from the BIR, similar to what was done when the sealed box ordered by this court to be returned to them. There is also a precedent during the 2012 Corona impeachment trial. The Senate issued a subpoena and thereafter awaited the return of the BIR commissioner. The requested records were produced only after the requisite presidential authorization had been obtained, one of the recognized exceptions under Section 71 of the NIRC. The respondent, however, is not without recourse nor remedy. In the event the requested tax records are lawfully produced pursuant to any of the statutory exceptions, the respondent may at the appropriate stage of the proceedings raise any and all objections concerning their relevance, materiality, authenticity, admissibility, and other evidentiary infirmities. The issuance of subpoena should not be construed as a ruling on the admissibility of the documents ultimately produced. On this basis, the subpoena shall therefore be issued, and we shall await the return of the BIR commissioner, at which time the court shall take such action as may be deemed necessary and appropriate. Accordingly, in view of the foregoing, the request for the issuance of subpoena directed to Commissioner Carlito Martin R. Mendoza of the BIR is hereby granted. The request insofar as it seeks the records pertaining to JTC Group of Companies Inc. and Pikimong Philippines Corporation is hereby denied for failure to satisfy the requirement of prima facie evidence. The Commissioner is directed to make the appropriate return to this court in accordance with the law on July 30, 2026 at 9 a.m. before the clerk of court. The court shall await the return before taking any further action as may be warranted. The parties are likewise directed to be represented by counsel on the aforementioned time and date for inspection, comparison, photocopying, and or marking as the case may be. So ordered. Senator Judge Alan Cayetano is recognized.
Thank you for the exhaustive ruling, Mr. Presiding Officer. I won't ask you to repeat it. Because you explained both in the focus and here that there are only two motions. There are parts, I'm talking about myself first, but I think some feel the same way. There are some parts that we agree, some parts we disagree. For example, to subpoena the certain records between 2022 to 2026. Then in my case, I agree with the know your client opening balance, just for reference so that you have a starting point. So may I suggest that instead of objecting, I don't know if I'm alone or with others, I will not manifest anymore, but may I submit in writing which parts of the ruling I disagree, and if anyone wants to either manifest or submit in writing. But I do have one question to the presiding officer. So you narrated everything. In the page 2 of the request for subpoena for 004, nakalagay, all records filed with, submitted to, or maintained by the BIR for taxable year 2007 to 25, including but not limited to. So sinabi 1, 2, 3, 1 and 2, pero not limited to. The other one, 4, page 4 of the request number 004-2026. Sorry, that's the case number. So the other one is to the, this one's to the anti-money laundering. Nakalagay po sa page 4 and all other relevant documents. So I just like to ask, was your narration exclusive? Because you did say that it's specific enough, but I don't think specific yung all other relevant. The test of if it's definite is that wala nang iisipin yung pinadala mo ng subpoena. So kung anong nirate, yun ang kukunin.
That is a common practice perhaps used by lawyers, but the understanding of the court, and let this be part of the ruling of the court, is that only the documents specifically mentioned.
Thank you for
and
that.
will not include that catch-all phrase, because I doubt if the banks, the BIR, AMLC, would be able to supply the and such others unless it was specific.
So with the permission of the court, I'll submit my where I
Permission granted, and any other